Hello. Good afternoon, sir. Hello.
Yeah, good evening, rather.
Good.
Can you hear me?
Good evening. Yes, sir. I have given live, sir. Already we are live.
No,
Can
I
you please
understood
start?
you're live. I'm asking you, is my audio and video clear or not?
Clear, sir.
Okay, great.
Oh,
Give me.
can I host you? 1 second, sir. I will co-host you, sir. Yeah, you may
Yeah.
go ahead, sir. Yes, sir.
Okay, done.
Thank you. Thank you, sir.
Very good evening. Welcome to this quick revision on, insolvency and bankruptcy code. Specifically, we are going to discuss and revise liquidation process, as we have had 20 different sessions, 10 hours of time on how to do liquidation, what are the provisions, what are the various regulations framed by IBBI. We've already covered that. And along with that, we also understood various case studies which give us far more clarity on how the provisions work and what are the intricacies involved and how the judiciaries, especially the adjudicatory authority and the appellate tribunal, look at various legal matters concerned to the liquidation process. Now, we are going to, in the next 1 hour's time, try and quickly revise as much as we can to, brush back the provisions and regulations and to, understand the process once more. And then in case you have any questions or doubts, we can try and interact on those questions and doubts. And in spite of that, if we are left out with any more questions, doubts, what I request my co-host is to maybe create one email ID specifically for questions posed by the participants. And you can also get into personal interaction with me offline if we are still not able to, have a convincing discussion on the matters. So you can also email us the questions or get in personal contact with me on phone and I can explain you various things. So let's go to the first slide in terms of revision and understand how the provisions work. Firstly, let's do a quick understanding of how or what is the legal framework for liquidation. Number one, part 2 of chapter 3 of Insolvency and Bankruptcy Code deals with liquidation, wide sections 33 to 54 of the IBC Code 2016. And along with that, we also have regulations formed or framed by IBBI by the name IBBI Liquidation Process Regulations 2016. So whenever a corporate debtor is getting liquidated, it's very important for us to understand what are the various legal provisions that will come into play, what is the act, what are the regulations, and apart from that, do I have to look at anything more apart from these is an important question. So firstly, whenever there is a bankruptcy scenario, we have to look at the Insolvency and Bankruptcy Code. Under that specific chapter pertaining to the activity. Like in the case of corporate insolvency resolution process, we have a separate chapter. And when it comes to liquidation, we have a separate chapter. So we have to look at that particular chapter. Wide sections 33 to 54, there are a lot of provisions made under the Act. And then we have IBBI, which is a concerned regulator, that have also framed certain regulations. So we have to look at all of them to understand how holistically a liquidation process will happen. So firstly, as we have discussed before also, I'm not going to really get into details, but let's quickly look at circumstances that create or that call for initiation of a liquidation. Basically, whenever there's an insolvency scenario, first we try to resolve the insolvency by way of a CIRP. And where CIRP fails, the last resort is going to be liquidation. Therefore, either COC decides to take the corporate debtor for liquidation, or the plan submitted by the resolution applicant and the insolvency professional, called as resolution plan, is rejected by NCLT, then the situation absolutely warrants for a liquidation. And the third and the most important circumstance is effects of time given for resolution plan. As we know, the provisions are already set as to within what time the resolution plan should be completed by the resolution professional. And if no measures have been taken, by effects of time itself, it warrants for a liquidation process. So these are primary three reasons which call for a liquidation scenario. And once we are talking about liquidation, it is handled by a separate professional called as liquidator. Who can be liquidator? We already know that insolvency professional himself can act as a liquidator as well. If I take you to the next slide, what are the effects of initiation of liquidation? What happens? We know the moment liquidation is approved or liquidation is initiated, then there are two important consequences. Number one, it acts as a moratorium. Therefore, there will not be any suit against the corporate debtor except with the sanction of NCLT, number one. Number two, all the employees and officers and workmen will be deemed to have been discharged from that day. Hence, this also acts as a notice for discharge of all the employees and workmen. These are the two important effects of initiation of liquidation. Then, who appoints liquidator? Very, very important. As I said, the moment we discuss liquidation is going to happen, liquidation cannot be handled or managed by anyone else except liquidator. Therefore, how do you appoint liquidator and who can act as a liquidator? Appointment of a liquidator always is done by NCLT. And therefore, we are saying under Section 34 of the IBC, NCLT is empowered to appoint a liquidator. The resolution professional who was till now dealing with the CIRP, failing of which has led to liquidation. Now the question is, can the same RP under whose monitoring or under whose supervision CIRP was done, can the same man continue as liquidator? Yes, RP himself can continue as liquidator unless the order specifies otherwise. So the most important point at this juncture is, if a liquidator is appointed, what is he going to do? Generally, remember one thing, as far as IBC is concerned, every step, every move of the liquidator and the resolution professional are carefully monitored. They are questioned by the committee of creditors. They are also questioned by the corporate debtor. They are also questioned by the regulator, the disciplinary body, and many other people are closely watching. Therefore, every liquidator, every resolution professional should always understand his limits. What are his express powers, which he can do? What is his role? What are the limitations to his power, which he cannot overstep? The moment he is overstepping any of these limitations lines that are drawn, then he is getting himself into trouble. Therefore, liquidators must necessarily understand what are the powers. So accordingly, the role of the liquidator is very clearly defined under Section 35 of the Insolvency and Bankruptcy Code. It says, The liquidator shall first manage the selling of the assets of the company. We always know what is the end goal of a liquidation. I'm sure all of you recall. Maybe just try to, recapture in your mind before I give you an answer. What are the three major steps involved in a liquidation? Number one, liquidator shall gather all the assets and make an asset memorandum. And there we've already studied what are the assets that can form part of the liquidation estate, what are the assets that cannot form part. After that, liquidator shall receive claims from the creditors as to who is actually entitled to claim what amount. After that, he should sell these assets for the best value that is possible. And after receiving the sale proceeds, he must distribute these proceeds equitably amongst the various creditors according to their claims. This is the whole purpose for which liquidator is appointed. So as part of this very, very important role, liquidator is expected to manage the selling of the assets of the company. We already know that there are various methods and modes for selling of the assets of the company, so he shall handle that. Two, he shall formulate a liquidation plan as to what steps he will take for completion of liquidation, and that plan shall be executed according to what he has formulated. Then, the company's assets must be disposed of. After that, the creditors should be paid, like we have already understood. Filing of claims for debts owed to the company. This is an important part. Like we have, if you have, watched all the sessions, heard me, and if you have actually seen the case studies there, we have very clearly specified that wherever the corporate debtor is expected to receive sums of money from third parties, most of the times, these sums of monies are not recovered by corporate debtor because they might be related parties, they might be close associates from whom these sums of money should be received. So, Section 35 of the Act makes it a duty of the liquidator to actually recover all the monies that are owed to the company by third parties. So you must make claims and to the extent possible receive maximum monies from the third parties which are owed to the corporate debtor. Then, representing the company in all legal proceedings, wherever there are legal proceedings going on against the company or initiated by the company, it should be a liquidator who should represent in all these legal proceedings. Then finally, he should report to the tribunal as to how the liquidation has taken place. Then, what is liquidation estate? I've been always talking about this. That Section 36 of the Act provides that liquidator shall first create a liquidation estate. Liquidation estate is nothing but a list of assets which will be part of the assets that the liquidator is going to sell. So he is going to recover the money by selling these assets which are clearly identified as liquidation estate. Let's see what are the inclusions in liquidation estate and what are the exclusions. Let's straight away go there. So if you look at the liquidation estate, the following assets will form part of the liquidation estate. Number one, assets on which debtor have ownership rights, such as leased premises. The corporate debtor owns a building or a land which is leased out to a third party. Though the possession is not with the corporate debtor, because the ownership rights are now vested with the corporate debtor, this will form part of the liquidation estate. 2. Intangible assets. What are intangible assets? We know that intangible assets are those which are not having any physical presence, such as intellectual property rights, trademarks, patents, copyrights, design rights are all called as intangible assets. You cannot really touch them and feel. Therefore, there is no tangibility to these assets. Those will also be part of liquidation estate. Then, relinquished security interest. If you have any securities anywhere, and if you have relinquished the interest, that will also form part of the liquidation estate. Assets in possession, including encumbered assets. Assets under dispute. Any property vested in corporate debtor at the beginning of the CIRP will now be part of the liquidation estate. Tangible assets such as movable, immovable properties. Then assets or value recovered through avoidance proceedings. In our previous discussions, we talked about 4 types of transactions, which are called as PUFE transactions. P is preferential transaction, U is undervalued transaction, F is fraudulent transaction, and E is extortionate transactions. These are 4 transactions which are commonly named as avoidance transactions, which can be avoided by the liquidator with the help of an order from NCLT. The moment an avoidance order is passed by NCLT, the assets which are recovered as part of these avoidance proceedings will now be part of the liquidation estate, and therefore those can be sold by the liquidator. Lastly, proceeds of liquidation will also be forming part of the liquidation estate. Now, what is the significance of this liquidation estate is this is the money on which the shareholders will have rights or the creditors will have rights, where the liquidation estate shall be distributed amongst these creditors. After the creditors have been given their full rights, then comes shareholders' interest. Therefore, this liquidation estate is the primary bone of contention for everybody concerned. Then, what are not included in liquidation estate? Assets owned by third parties are not covered. Workmen's dues, employees' dues are not covered, which we've already understood. Assets in security, which are given as collateral. Assets held in trust for a third party, non-transferable contractual assets. Then personal assets of shareholders, partners, then bailment contracts, etc., are not to be considered. Just give me one moment. Okay, this said These are certain exclusions which will not be part of the liquidation estate, and therefore these cannot be distributed amongst the creditors. Assets belonging to the subsidiaries of the corporate debtor, other assets as notified by the central government, none of them can be actually, admitted as liquidation estate. Verification of claims. How does a liquidator verify claims? Are given in section 39 of the Act. Accordingly, we said liquidator must verify the claims submitted under section 38 within the stipulated period specified by the IBBI. In IBBI regulations, we clearly have the timelines defined as to within what time things should be done by the liquidator. The liquidator may ask any creditor, corporate debtor, or any other person to provide additional documents for substantiation of his claim if he is not convinced with the documents submitted for the claim by the creditor. As we know, Section 40 empowers liquidator to, admit or reject a claim after the creditor makes a claim. However, liquidator shall not arbitrarily reject any claim unless he finds a reason for rejection of the claim. The first and the foremost reason for rejection of a claim is lack of evidence that substantiates the claim by the third party against the corporate debtor. However, the one point that must be noted is whether admission or rejection, the liquidator is bound to communicate within 7 days of his decision to the party against which or in favor of which a decision is taken by the liquidator. Now we come to another important part of the provisions of IBC. Section 42 says where a certain claimant is totally dissatisfied or aggrieved by the decision of the liquidator to accept or reject, then he can make an appeal. However, important question is, if the claim is already accepted, where is the question of grievance? Where is the question of going for an appeal? Remember, the liquidator may partially reject the claim and partially accept the claim. In case the liquidator does not totally admit the claim, then in that case, the claimant will have a right to appeal under Section 42 to the adjudicating authority, which is NCLT. However, this appeal must be made within 14 days from the date of rejection by the liquidator. What is the position of creditors during the liquidation process? There are 4-5 other important sections which we have left in the revision part because these deal with preferential, undervalued, fraudulent, and extortionate transactions, which are already explained in the slides, and you can always go through those recordings to understand those transactions. In the revision, we have skipped them because they're going to be extremely time consuming. So, Section 52 provides that a claimant, a secured creditor, will have two choices when it comes to liquidation proceedings. Either he can choose to be part of the liquidation proceedings and relinquish his right on the secured assets. So now he's as good as any other creditor because he doesn't have any more assets. He gave his right and is now claiming under the IBC. Then he will come to the claims under Section 53, which is waterfall mechanism. However, on the other hand, the creditor may also decide to realize its security interest in the manner specified in the section. So he can take the asset and walk out of the entire liquidation process, in which case such asset will not be part of the liquidation estate, and this asset will now be with the secured creditor who has the rightful right on that particular asset. But we also remember the case laws where, NCLT has clearly said that unless 60% of the entire credit amount is owned by one single creditor, he cannot walk away with the secured asset. Let's come to very, very important part of the entire discussion, which is called as distribution of assets. This is also called as a waterfall mechanism within the IBC jargon, and that means that the water, when you're looking at a fountain, there are different layers of water, right? So first layer of the water will fall in the first bowl, and then it comes to the second, and then third and fourth. So who will be the first of the creditors who can capture the liquidation estate or the amounts realized under liquidation? Number one, it will be secured creditor, and the workmen together will have the first right on the liquidation estate or the assets, right? However, both of them have their own limitations. When it comes to worksmen dues, only the worksmen dues which are pending for the last 24 months will have priority. And in the case of secured creditor, he will have the right over the liquidation estate under Section 53 only when he has actually relinquished his asset. Then comes employees, wages, and any unpaid dues for the period of 12 months preceding the liquidation date. See, mark the difference. Here, it is always workmen, but here it is employees. Workmen are the people who are directly contributing to the production, and therefore their dues will come first. And employees are more in the administration, therefore their claims will come second after the workmen and the secured creditors. Then comes financial debts owed to the unsecured creditors, and then lastly, any amount owed to the central state governments. After that, secured creditor for any amount unpaid following the enforcement of security interest. You must remember that when secured creditor walks away with his asset, he sells the asset, but what he recovered is less than the amount owed to him. Then for the balance money, he can always come under Section 53 and make his claim. So if there is any such claim, now that claim will be ranked at the fourth level as you see here. After that, any other remaining debts of any kind whatsoever. Once all the debts have been fully paid, then comes preference shareholders, and after that, equity shareholders are the partners. The word partners is used here. In case of LLP, partners can come in. Otherwise, it's going to be equity shareholders in all cases. Then Section 54 talks about resolution of a corporate debtor. This is perhaps the last of the sections that is dealing with liquidation. It says that where the liquidation is completed and the liquidation asset is distributed amongst the creditors, then the corporate debtor can be dissolved. How many of you remember the difference between the liquidation and the dissolution? We said liquidation is a process where assets are sold, monies are realized, the debts are cleared, and remaining surplus is paid to the shareholders. This is liquidation. Then what is dissolution? Dissolution is nothing but the last step of nailing the coffin, where there is nothing left out in the company. It has now remained as a pure shell. Therefore, we are going to dissolve this company totally. So these are few things that one must remember. Dissolution of corporate debtor is different from liquidation. Liquidation is a process, and dissolution is an end point where this brings about a complete end to the corporate debtor, and its name will be struck off the register maintained by the ROC. A copy of an order shall be forwarded to the ROC within 7 days from the date of such order, where On an application filed by the liquidator, the NCLT will pass an order for dissolution. Remember, the action of dissolution is not taken by NCLT because the company is incorporated and is entered in the records of the ROC. Therefore, only ROC can actually strike off the name. Hence, NCLT only passes an order, whereas ROC actually executes this order of dissolution, and after that, the company will not be in existence. So these are few important sections from 33 to 54 that deal with liquidation, and last one is dissolution. Now, if we want to go back and understand what are preferential transactions, which we've already done, we know where one party gets a preference at the time of liquidation, or when the corporate debtor and its management are anticipating a liquidation or a CIRP to begin sooner or later, they might enter into some transactions giving preference to certain parties. Those preferential transactions can be avoided. This is what we've understood in the past. I don't want to really, drag into these topics now again. It will take a lot of time. You can always write back to us in case you have any more questions on these transactions. Let's then come to 44. What types of orders can be passed if there exists a preferential transaction? Then the NCLT may order for recovery of such property, and then it can be part of the liquidation estate. Then let's come to next one, which is called as undervalued transaction, where assets of the companies are sold for a value which is less than the fair value. So sometimes they can be a gift, or sometimes they can be a transfer of asset which is for less than the fair value of the asset. In those cases, it can be called as undervalued transactions. Corporate debtors usually do this in anticipation of a liquidation or a CIRP, where they transfer valuable assets to their own relatives at a underprice. And therefore, these transactions should be reversed so that the liquidation estate gets the best value and the creditors can be paid as much as possible. So I'm not going into depth of this transaction again. I'm sure you remember most of the discussion that we had. Let's come to 47. The application for undervalued transactions are always made by creditors, and NCLT will pass an appropriate order. And then we said transactions defrauding creditors. There can be certain transactions which are taking place with a specific intent to defraud creditors. That is, creditors' properties, the properties of the corporate debtor can be put under litigation deliberately with an intent to make these properties out of the reach of the creditor. And those kind of scenarios is what we call as transactions defrauding creditors. And then again, these transactions can be reversed and the properties can be recovered. Last one is extortionate transaction. Extortionate transaction would mean phenomenal amounts of money have been taken away from the company for reasons best known to the parties to the transaction. So most of the times what happens is when the corporate debtor is in extraordinary need of money, people who are lending monies to the company, whether they are related parties, outsiders, or institutions, may charge phenomenal amounts of interest rates. Then those are called as extortionate transactions. These extortionate transactions can also be reversed so that maximum monies are recovered by the liquidator, and then those amounts are distributed to the creditors. Lastly, very, very importantly, what is the liquidation process? Before I get into this, I would request all of you to just please, in your own mind, try to recap as to what exactly is a liquidation process, what is the first step, and what is the last step. If you have a pen and paper, maybe you can quickly jot down in the next 1.5 minutes as to what are the steps. Recall value will be higher. At least in your own mind, you can think of what steps a liquidator will take and how the liquidation process begins and what is the last step for liquidation. Okay, so if you have thought over, let's look at what are those. Number one, first is what circumstances will call for liquidation. We know failure of a resolution plan, efflux of time, application made by the COC, and lastly, contravention of a terms and conditions of resolution plan will lead to liquidation. If that is the case, then COC's decision for liquidation will be important, and then an application by RP will be made for liquidation. After that, a liquidator is appointed. Remember, this is a decision made by the COC. Because this decision is made by the COC, as a liquidator or as an RP, this man should make an application to NCLT. NCLT will approve the liquidation and then appoint a liquidator. So, once the liquidator is appointed, he will inform ROC and IBBI. This is an important step. Remember, liquidator is under continuous supervision and monitoring by the regulators and disciplinary bodies always. Therefore, the first thing that he's going to do is he's going to inform ROC that, boss, now the liquidation will be taking place as I'm now appointed as a liquidator. What is the benefit with that? The benefit is simple. ROC would know that there will not be any more filings happening. It is only now liquidator which will do the filings, and RP is no more in the picture. It is all now going to be taken up by the liquidator. Then he should also intimate IBPI. Why? Because IBPI is the regulator who is monitoring the liquidator, and he has to submit frequent reports to IBPI to update the status. And we all know liquidator is operating in a strict, tight timelines. So to facilitate this monitoring, intimation to IBBI and ROC is very important. After that, he makes a public announcement. What is a public announcement? Public announcement in simple terms is nothing but he's intimating the public at large that, boss, so-and-so company is under liquidation. I am the liquidator of the company. And once this company is liquidated, you cannot get any money from this company. Therefore, if you have any claim to make against this company, make it now within the next few days. He was going to give the timeline up to which he is going to accept the claim. So within that timeline, you should make your claim. That's called public announcement. Now, once the public announcement is made, he is going to receive the claims from the various claimants. Claimants are broadly two types. Remember that. Number one is a financial creditor. Other one is an operational creditor. We remember all this knowledge from our CIRP proceedings. Once you receive the claim, what is the next step that the liquidator is going to take? He shall prepare a preliminary report as to what are the claims that he has received. Then the very important step that is going to take at this stage is verify the claims and understand who are rightfully deserving to get this sums of money, accept those claims if there is a substantial evidence in hand to prove their claim, and where they do not have any claim or any evidence to their claim, then reject such claims. Then he has to realize the assets. How does he realize the assets? We said he can sell the assets either by way of a public auction or by way of a private treaty or any other arrangement which he thinks is appropriate.
अगर वो नहीं है किसी भी रीजन की वजह से, तो उनको रिलेशन बनाने में क्या ज्यादा मजा आता है?
I'm sorry, there is some interruption somewhere. Is somebody asking a question? I request the participants to be on mute, please, unless you have a question. If you have a question, please tell me that you have a question and then maybe I can address it. Anyone has any question at this stage? Okay. So after the verification, realization of the assets, then all the realized money should be kept in a separate bank account, and from there, he should distribute the proceeds to various parties according to the waterfall mechanism as provided under Section 53. And once the entire process is completed, he's going to make a final report and submit that to NCLT and seek an order for dissolution. NCLT then passes an order for dissolution. The same will be filed with the ROC, intimating him that now ROC can strike off the company and dissolve it. ROC will do the final nail by, striking off the name of the company. This is the entire process of liquidation. I want to, take a pause at this stage and understand if anyone has any question, any doubts that need to be clarified, or maybe we can continue for next 10-15 minutes. Anyone has any specific question relating to process? Either you can, yeah, please go ahead.
Sir, if a personal insolvency is filed against the guarantors of a company, and these personal guarantees have loan with the bank, and they are
Sorry,
collateral.
I'm losing your audio. Would you repeat that?
Hello.
Yeah.
Sir, it is regarding this personal insolvency. And the bank has filed a personal insolvency against the guarantors of a corporate debtor. Hello?
I'm still not able to get your voice very clearly. Can you come closer to the mic, please?
Hello? Sir,
Yeah.
it is regarding personal insolvency.
The
bank has filed a personal insolvency against these guarantors of a corporate debtor.
Right.
And this corporate guarantor has these properties with the bank in another loan account.
So you are saying personal insolvency against the guarantors is running simultaneously with the liquidator. This is your question.
No, actually, my question is, a corporate company and this guarantors are, the bank has filed a insolvency against corporate guarantors.
Okay.
If and all their properties will come under this liquidation estate only.
Yes, correct.
But if that assets are with the bank, in another loan account, what will happen? This corporate guarantees has another loan which they are paying, correctly.
So if you're a corporate guarantor and if there is a CARP initiated against such corporate guarantor, what is the consequence you're asking me?
No, if they have another,
would you please put this question on chat, please? It will be great help.
Okay, I will type it.
Yeah. Meanwhile, any other question? Anyone else can also keep typing your questions. For the sake of clarity, I think I request all of you to please put your questions on chat. I only received one question here, which is asking whether I can get a video recording. Uh,
बात करें लड़का लड़की होगी तो किसको ज्यादा अच्छा लगता है और
Yeah.
समय बढ़ाने पे क्या असर होता है इसकी बात करें.
I have the question now. I can read it.
करते हैं जब भी ऑपरेशन बना.
Okay, so that's a very good question. So usually, remember when there is a specific charge, specific mortgage on the asset, on a particular asset, that particular charge holder will have the first right on that asset, right? And any subsequent charge, mortgage created on that property should be done with the consent of the first charge holder. If there's a consent of the first charge holder, then there will be ranking hierarchy of the charges. Accordingly, then such asset can be brought under the process of liquidation or CIRP. Even though there is another party which is having, charge on such assets. But where there is a general charge created without specific consent of the first party, which has a first right on such asset, then you cannot bring that under liquidation or CIRP. I hope your question is answered.
One more doubt.
Yeah.
So if that account is not NPA, it will not come under this CRP process.
Sorry, and I am not. Can you please type that question as well?
Okay.
Because there's a lot of echo on the mic here.
Okay.
Are you a banker by any chance?
Yes, sir. Yes, sir.
आते हैं तो क्या ज्यादा अच्छा लगता है. नेक्स्ट, अगर आप अपने हेयर को प्रॉपर तरीके से ट्रिम करके रखते हैं या फिर पूरी तरीके से वहाँ पे क्लीन रखते हैं तो ज्यादा अच्छा लगता है.
Madam, your voice is really cracking. I think I prefer a chat message. It will be great if we have quick messages on the chat. Yeah, good question. So, though I'm now right now answering Mr. Muhammad Ali's question. If both loans are in the same bank, can the bank bring all the properties in the CIRP process? Is something that has to be examined carefully, because when a particular loan account is already an NPA of the same corporate debtor, I'm sure other corporate debtor, the loan is also becoming an NPA. It is rare that one loan is honored, it is being paid on time, and the other loan has become an NPA. So once the CIRP is initiated, I'm sure no banker will get back his money, and all the loans will almost become the same. And therefore, all the assets can be brought under the CIRP process. Now the question is, as a creditor, do you want to bring all the assets under CIRP process or realize the assets and walk away? Subject to the terms and conditions. So if you want to bring all the assets under CIRP process, yes, you're allowed, as long as they are mortgaged to you and as long as there is an NPA of that particular loan account. I hope this is answered.
Sir, if that is personal guarantor, I mean, if let's say a company with the name
No, as far as personal guarantor is concerned, you cannot act like that. Personal guarantor gives a guarantee specifically with reference to certain loan. And therefore, your banker or the lender is bound by only that particular guarantee document. It cannot be a random document, that can be applied anywhere.
if personal
In
guarantee,
my view, you cannot bring those assets under CIRP.
okay. So I mean, okay, understood.
Yeah, some of these questions, I think we can obviously take it offline sometime. I can give you my phone number, mobile number. You can call me or mail across all your questions. We can take them through.
Okay, kindly share it, sir.
Yeah. I request the host also to create one mail ID specifically for these interactions, so we can take some time and keep replying to all these questions.
Sir, we do have a discussion platform, sir. We'll share the link of the discussion platform so that you can take the queries.
In that case, please share my phone number with them. So please always message me on WhatsApp so that I can get in touch with the participant.
No, sir. There's a separate discussion platform that is there. We'll share the link of the platform, sir.
Okay,
That will be
great.
sufficient.
Great.
Okay,
That will
sir.
be helpful.
Yes, sir. I'll share it right now, sir.
Yeah. So I think if there are no further questions, we can stop the session here today. And I think once you people are thoroughly prepared, we can have next interaction again. Madam, can we close the session, Sharda Garu?
Yes, sir. Yes, sir. We'll, as you said, sir, we'll take the queries in the discussion platform if there are some more. Sir, am I
Sorry.
audible?
Yeah. Would you repeat that, please?
Yes, sir. I was saying that we'll be taking the queries as you said in the discussion platform, sir. And if
Okay.
there's nothing else, we can call it a day, sir.
Sure, we will do that.
Yes, sir.
Okay. Thank you so much, everybody, for patient hearing. We will soon again interact to the extent possible and try to bring more clarity on the subject. Thank you so much, Sharda Garu, for hosting this session.
Thank you. Thank you so much, sir. It was an interactive session, sir. Thank you, sir.
Yeah, sure. See you soon. Thank you.